Good afternoon, Mr. Doe.
Good afternoon, Mr. Ramani.
You've offered an opinion in the alternative as to the damages that Mr. Goy claims to have suffered. Is that correct?
Not quite. It was actually Mr. Fitz who claimed the damages.
Oh, excuse me. Let me ask that again. You've offered an opinion, alternative opinions, as to damages that Mr. Fitz claims to have suffered in this case. Is that right?
That's correct, yes.
The first of those opinions is that Mr. Fitz should recover 1.5% of the IPO value of T6. Is that correct?
Yes, that's correct.
That's based on an offer that Mr. Goy received from a company called Bluefish.
It was an offer that Mr. Fitz received from Bluefish.
I
Yes.
keep using the wrong names. That's based on an offer that Mr. Fitz received from a company called Bluefish. Is that right?
That's my understanding, yes.
What was the date on the offer letter on which you based your opinion?
It was June of 2001.
How many pages was that letter?
I'm not sure.
Do you have a copy of it that you reviewed?
No, I do not.
Did you ever review the letter?
No, I did not.
You didn't even look at it before forming your opinion.
I inquired about the contents of it.
Who did you ask about what this letter said?
I asked Mr. Fitz.
What did he tell you?
Mr. Fitz described the letter to me as having come from Bluefish and containing a base salary of $150,000 a year and granting him 1.5% of the company in the event that his algorithm was incorporated into a commercial product.
Did Mr. Fitz mention any other terms in the offer letter?
Not to my recollection.
To your understanding, Mr. Fitz's algorithm addresses fast packet switching. Is
Yes,
that right?
that's correct.
That's a networking technology.
Yes.
Bluefish, this company that gave Mr. Fitz an offer, was a networking company.
Well, yes.
And so a networking company you would expect have use for a networking technology, as Mr. Fitz claims to have created. You would agree with that?
Yes.
T6, the company that's being sued here, is a network security company.
Yes, that's correct.
I know you're not a technical expert, but you'd agree that network security is different than networking, wouldn't you?
Well, they both rely on the network.
So do lots of things, but isn't network security itself a different field or a different area of focus than networking in general?
Well, I would characterize it as network security and networking overlap. I don't know that they're entirely different fields.
Have you done a comparison of T6 and Bluefish to support that view?
No, I have not.
Is that something that you think you should have done before forming your opinions?
No.
Let's move on to the second of your alternative opinions, the Nash bargaining opinion. Let's talk a little bit about the Nash bargaining solution. The Nash bargaining solution attempts to answer the question of how economic surpluses get divided. True?
Yes, that's correct.
Put another way, a lot of folks might know that the Nash bargaining solution applies a 50-50 split. But before you can apply that split, you have to calculate an economic surplus. You agree with that?
Generally, yes.
A surplus is not simply the benefit that two parties might obtain when they cooperate. There's more to it than that, right?
There is some more to it, yes.
The surplus is the benefit from the parties cooperating minus the next best alternative if the parties did not cooperate.
That's correct, yes.
The next best alternative, if the parties did not cooperate, could be a completely unrelated product. You agree with that?
Yeah, in the hypothetical, I'm struggling to see how that relates to this precise case. But
let me ask you about this precise case. What did you do here to calculate the surplus as part of your Nash bargaining analysis?
Well, I looked at the the options that were granted to Mr. Goy by T6. And the my understanding is that without the trade secrets, Mr. Goy would not likely have been hired by T6. And so I was conservative and didn't include Mr. Goy's salary in my calculation, but those options represent the economic surplus in this case.
You said that it's your understanding that T6 likely wouldn't have hired Mr. Goy without the trade secrets. On what do you base that?
My conversations with counsel and with Mr. Fitz.
Okay, so you spoke with the plaintiff and the plaintiff's lawyer, and on that basis concluded that T6 wouldn't have hired Mr. Goy without the trade secrets.
Well, it was my understanding that Mr. Goy's knowledge of the trade secrets was important to his hire. And having not just my conversations, but in reviewing the documents, there are emails discussing the meetings between the T6 people and Mr. Fitz and Mr. Goy, and there was some question about whether or not Mr. Fitz should be brought along as well, and it was pretty clear from the documents that the trade secrets were important here.
You didn't rely on a technical expert to review those documents and advise you that, yes, in fact, it looked like the trade secrets were important in the decision to hire Mr. Goy. You just came to that conclusion on your own after speaking with the plaintiff and plaintiff's counsel?
Well, and as I said, in reviewing the documents, which I think on their face would support my conclusion that the trade secrets were actually important in the hiring of Mr. Goy.
Did you see any testimony from anybody other than the plaintiff in this case that came to the same conclusion? That the trade secrets were important in hiring Mr. Goy?
I recall some emails. I don't recall the specifics of them, no.
So no testimony that you remember?
No, nothing I'm aware of. Nothing I can point to as I sit here today.
The Nash bargaining solution operates under some assumptions, a set of assumptions like any theory. You agree with that?
Yes, that's
one assumption is that the parties are perfectly rational.
yes.
In your experience out in the real world, parties don't always act rationally in negotiation. You agree?
I think that while deviations from rationality are relatively common, I think that on average what you get is a rational response.
Is that different in your mind than perfect rationality that's required by the Nash bargaining solution?
It's different from perfect rationality. I'm not sure I quite understand the question, but let me try to answer it by saying that while you can dispute whether or not every individual is rational, that if you take essentially an average across all individuals, you get something that approximates rationality.
So, putting it another way, while each individual negotiation may not be perfectly rational, when you accumulate a whole bunch of different negotiations, you get something that, in your opinion, approximates perfect rationality.
Well, it approximates rationality. I'm not sure what the word perfect adds to this.
The Nash solution also assumes that the parties have perfect knowledge of each other. Do you agree with that?
But that's correct.
In your experience in the real world, it's almost never the case that the parties have perfect knowledge of one another. Sure.
In the real world, that's true. However, the hypothetical negotiation allows for things like peeking into the book of wisdom. There's also a phrase that gets bandied about how both sides in the hypothetical negotiation lay their cards on the table.
The Nash solution also assumes the negotiation's outcome is independent of irrelevant alternatives.
Yes, that's
True.
correct.
Another way of saying that is that in the Nash solution, each deal is unique. You'd agree?
Yeah, I think that is true, that the Nash solution, each deal is unique. Yes.
Now, I guess what that means is that each deal is unaffected by past deals,
Correct.
and each deal is unaffected by potential future deals.
That's correct.
Now, in the real world, as again compared to this theory, studies have shown that irrelevant choices actually impact the decisions that negotiators make in a statistically significant way. You're aware of that social science research?
Yes, I am.
Do you agree with it?
It seems to be well done research. I have no reason to disagree with it.
Did you consider that research in deciding to apply the Nash bargaining solution in this case?
Well, the research that I've looked at, clearly there are people who've tested assumptions around the Nash bargaining solution. And Nash bargaining is a theory, and it relies on assumptions, as all theories do. And while you can quibble with whether or not each of these assumptions is valid, the brilliance of Dr. Nash, that he received a Nobel Prize for, was understanding how a negotiation winds up when you go through this really elegant mathematical construct that he put together.
Isn't it the case that Dr. Nash's theory requires the assumptions we've discussed before you can apply the 50-50 split? Isn't it a precondition?
Well, it certainly relies on those assumptions, yes.
Now, let's talk about the broader economic community. You consider yourself a member of that community?
Yes.
The economic community has never accepted the Nash bargaining solution as an accurate predictor of actual outcomes. Do you agree with that?
I think I'd have to agree with that, yes.
Thank you. Good stuff.
With respect to the offer letter, you were asked, did you know of any other terms of that offer letter? And I believe you said no. What do you know about that offer letter? Do you know enough?
I believe that I do know enough, yes.
And why is that?
Because I had extensive conversations with Mr. Fitz about what the contents of that offer letter, and the really material provision in there to me was the 1.5%, and that was a very clear recollection on his part.
And do you feel that what you know of the offer letter was sufficient to base your opinion upon?
Yes.
And in your opinion, does it matter as to whether you were described the terms of the offer letter or actually saw it in writing?
I have no reason to doubt Mr. Fitz's characterization of the offer letter.
You were asked some questions about the difference between a networking company and a network security company. Do you remember that?
Yes, I do.
Does that difference matter to your opinion here?
I don't believe it does. I think the technology at issue here was looking to be employed by either one of these companies, and perhaps it was in a slightly different venue, but I didn't see where the precise industry definition that you decided to categorize a company into really mattered.
I'd like to ask you a little bit about the Nash bargaining solution testimony. You mentioned, you were asked about whether the trade secrets were important in the hiring. Do you recall those questions?
Yes, I do.
And tell me how and why you looked into that issue for your opinion.
Well, I was asked to make this assumption by the attorneys that the trade secrets were actually an important factor in Mr. Goy's getting hired. And I understand it's my responsibility as an expert to validate, to go and make sure that that actually is a reasonable assumption to make. And so I reviewed the documents, and at the end of that document review, I came to the conclusion that, yeah, that's a reasonable assumption to make, but I'm not offering a liability opinion on that, if that's what you're asking.
Thank you. On Nash, you were asked a number of questions about the deviations of or assumptions that go into Nash. Do you recall that?
Yes.
Those questions? Do you believe it was appropriate to use the Nash bargaining theory in this particular case?
Absolutely.
And why is that?
Well, the Nash bargaining theory is a really prominent leading a theory that in the general economics field of game theory, and what Nash won the Nobel Prize for was being able to develop a construct that actually gave an answer to this question that before Nash had been indeterminate, which was how do the surpluses get divided in a negotiation? And Nash built this absolutely elegant theory behind it, and the result of that theory was a 50-50 split. And so I simply applied the leading game theory to this existing negotiation, this situation.
And there wasn't an actual negotiation to split a trade secret surplus in this case, is that correct?
That's correct.
Is that, so you had to use some type of model, is that correct?
That's correct, yes.
Was Nash a good model to use in this circumstance?
I would say it was better than a good model. I would say it was the best model that was available.
You were asked some questions about the Nash assumptions of rationality and perfect information. Is that, do you remember that?
Yes.
Let me ask you this first. Has Nash been used by other courts in assessing damages in similar cases?
It's certainly been used by other courts. I don't know the details of how exactly it's used.
Okay. And in other real-world situations, would you expect that there may be some differences or issues as to perfect rationality or perfect information?
Yes.
And so given what you know about the rationality and the information that the parties in this case had, do you think it's appropriate to apply Nash here?
Yes, I do. I think that in any damages work, you're building a model, and because the fundamental precept of damages work is to try to understand the but-for world. What would the world have been like without this bad act? And that necessitates building a model. And models are always imperfect, and we do the best job we can. And I believe that in this case, this is the best and the most appropriate model for the damages.
And the model approaches you mentioned, it has to be used in a case like this because there wasn't an actual sit down across a table and split a trade secret surplus, correct?
That's correct, yes.
The assumptions that we've walked through, Mr. Doe, relating to the Nash bargaining solution, all of those assumptions have to line up before you apply the 50-50 split called for by the theory, correct?
Right, the theory does rely on those assumptions.
I want you to assume that just one of those assumptions is off. Let's take the assumption of perfect knowledge of each other by the parties. If the parties lack perfect knowledge of each other, then under the Nash bargaining solution, the preconditions are not met to apply the 50-50 split. You agree with that?
That's correct, yes.
Is there any guidance that you get from the Nash approach as to what split to apply? Or to put it another way, you can't say whether it would be appropriate to apply some different split, 70-30, 30-70, 60-40 in that circumstance.
I would agree that the only split that the Nash bargaining solution gives you is a 50-50 split.
Let me ask you a follow-up question about that. He asked you about perfect knowledge and whether if you don't assume perfect knowledge, you can apply the Nash bargaining solution. You recall those questions?
Yes.
And do real-world bargaining parties ever have perfect knowledge of each other?
No, they do not.
And yet courts have applied the Nash bargaining solution, haven't they?
Well, they've relied on experts who have applied it, yes.
And do you believe that the assumption of perfect knowledge as applied in your opinion here, is there enough information to use that assumption and apply Nash here?
I think that the situation here is not that different from my understanding of the other situations. And there's nothing in this particular situation that would cause me to characterize it as an unusual negotiation.
So it's your opinion that Nash is an appropriate model for this situation?
Yes, I think the Nash bargaining solution is the best available one for this situation.